Hey guys, welcome to Power of Attorney. I am your host, LeTonya Moore, and I am so excited, guys, about today's episode. We are going to be talking to criminal attorney Victoria R. Clark. She is going to be discussing several things. Of course, criminal law, guys, is so vast. I know that our listeners have been asking about things like attorney-client trust. Like, can you really trust your attorney not to sell you out in criminal cases? For you guys that may or may not have seen this, there was a New York Times article about the plea bargain trap. And so we are going to be touching on some of those things, again, attorney-client trust. We are going to be talking about the plea bargaining process. And Victoria and I will also be talking about understanding your case and really just the chances of winning by going to trial, because, the plea bargain process is there and there is a reason for that. She practices in Washington, D.C. The name of her firm is Clark Law, PLLC. And so without further ado, please welcome Victoria R. Clark. Welcome, Victoria.
Thank you. Excited to be here.
Awesome. So I always love to interview criminal lawyers. You guys really rock, because at the end of the day, you really are on that front line while the rest of us are in the office. But seriously though, I think that oftentimes people do have some challenges when it comes to criminal lawyers and how to pick the best lawyer, how to deal with can you trust your attorney in a certain process. Talk to us a little bit about your perspective about attorney-client trust and just some words of wisdom that you would have for people as they're looking at who to choose.
Sure. So I'll say that there are a few differences between attorneys. And so when you're talking to a prospective attorney that you're considering retaining for your case, certainly you want to consider the cost. You want to consider their method of communication. And you want to ask them, what will you do to resolve my case? Now, an attorney might not keep you apprised of every single move they're making. But I guarantee you that most attorneys at the forefront of their mind are doing everything they can for their case, especially in terms of criminal defense. And we just don't want to lose our licenses. So it's incumbent upon all of us to be really the best that we can be. And by being the best we can be, we get great outcomes for our clients. We get more clients, and we, of course, retain our licenses.
Awesome. And I think that people probably don't really think about that because, of course, a lawyer losing their license is not something that you see all the time, but it is a real possibility, right? It is a real possibility. I mean, there can really be a level of incompetence where that can happen. And I think that, too, on the other end, though, and I love the fact that what you were saying about ask questions, right? You want to know from this attorney, how many cases like yours have they had, how have they handled before? Because just because someone is a criminal attorney doesn't mean that they have experience in your case, right? If you are, let's say you are charged with a sex crime, but this person primarily, let's say that they do, drug trafficking or drug possession cases, and they may be very popular in the community because of the type of cases that they do and because of their expertise in that part of criminal law. And so what do you think, Victoria, in terms of how easy is it, like, for example, with the example that I gave, let's say that the client does go and they do have a case and this attorney says they may have lots of years of experience, but they say, well, I really haven't done a lot of, let's just say, sex crimes cases, but they've done a lot of criminal possession cases. What are some things that someone sitting in that attorney's office can ask that particular attorney so that besides the fact that they haven't done a lot of cases, what are some other things that they can consider if they otherwise like the attorney?
So I would say that if in your example, someone is charged with a sex offense and are speaking with an attorney who the bulk of their practice has been in drug cases, that does not necessarily rule out the competence of that attorney. Because let's look at some of the questions you could ask that are really going to show the similarities of those practices. So one, how many of those cases has the attorney taken to trial? So if you are looking for a criminal defense attorney who has never taken a case to trial, you should leave their office. Because if it comes down to it, if, as we'll talk about later, you don't want to take a plea offer and you need to take that case to trial, that attorney's not going to know how to do it. You want to ask them what type of process they go through in investigating and defending their client, especially in the pretrial process. So, for example, do they work with an investigator, or do they make the calls and do the investigations themselves? What court are you in? So there are certainly different courts in every jurisdiction, local courts, sometimes different local courts, federal courts. You want to ask the attorney what their experience in each particular court is. That will judge their level of comfort in the court, their level of experience with those prosecutors, and their level of knowledge about the judge that is going to be handling your case. And all of those things can really come in handy when it comes to defending your specific case. But as far as the different types of crimes they've done, you want to know that they know how to read forensic reports. That's going to be very important in most types of cases.
Awesome. And that's really, really great sage advice. And you also bring up something else about knowing the judge, understanding the jurisdiction that you're in, because even in the same metro area, there are always several different jurisdictions. I mean, unless you're just, in some obscure place, but for the most part, there will be multiple jurisdictions that one attorney may be practicing in. And so your jurisdiction, you want to know what's going on, what experience that they have. So that's really great advice. I want to also ask you, though, about understanding your case and your chances of success, because I think all of the things that you just mentioned really speak to that and speaks to the ability to be able to do that. Talk to us a little bit more about what does that mean, and what is the impact of understanding your case and your chances of success at trial?
Sure. So first is, you as an individual know whether you did what the government is saying you did or not. So for example, I'll take something a little more simple, like a DUI. You know whether or not you were drunk in the car before you were arrested. So if you know you actually did what the government is saying that you did, you can knock some points off in terms of how likely you are to beat the case, because that increases the risk of the government having just more evidence against you. If we're talking about some cases in some jurisdictions, the police are equipped with body-worn cameras. And so if, for example, in a DUI case, the police arrested you with their body-worn camera turned on, you're slurring your words, you're stumbling, you have bloodshot eyes, you might have said on camera, oh, I only had a few shots of rum. Well, that's kind of a time where you want to discuss with your attorney, look, this is my situation and this is what happened. And of course, you want to be truthful with your attorney, because the attorney is going to discuss a strategy with you. And then as they receive discovery, they want to make sure that the discovery they receive from the government matches up with what you're saying we're also have to remedy those discrepancies, and that may impact their assessment on whether your case is likely to succeed at trial or not. Now, I will give the caveat that there might be something in your case where the police did something that was unlawful. Maybe they searched you and they had no probable cause to search you. That's information that you'll receive from your lawyer about whether or not your case is winnable on some type of other grounds other than whether or not you actually did it or not. So that is definitely something to take into consideration. And so I always recommend giving your attorney all of the information that you have without making any assessments on, whether the police were doing something legal or illegal. Just give the attorney your narrative of what happened, all the information that you have, and your attorney will be able to give you a good assessment of what would be the best route to take. And certainly some clients come to me, they say, I definitely want to take the trial. Some clients come to me and say, I definitely do not want to take the trial. I just want to plead guilty and be done. I know I did it. I just want to get through this. And some will say, you know what, I might have done it, but we're going to make the government prove that I did it. So I got all the time in the world to fight this case.
Right. Absolutely. And again, that is really great advice, because you have to understand that your situation as an accused is not unique. And I think sometimes, and really, this is not just in criminal law. Those of us that practice business or civil law or any of the other areas, we all deal with clients that, to the client, they are your only client. So they don't understand oftentimes, or maybe they do, and they may not be considerate of the fact that there are multiple things that are going on. And so, you've had experience with other people. Like, this is not just the only person in the world that's ever been charged, in our scenario or hypo, with a sex crime. And so for you to not listen, really, but you have to understand, at the end of the day, it is your life, it is your decision. But again, like the three different options that Victoria mentioned, some people don't want to go to trial. Some people say, I didn't do it, I want my day in court. Some people say, I did it. But let's just see, let's roll the dice. And so that kind of brings us to the New York Times article, Victoria, about the plea bargain trap. Now, I know criminal lawyers really throughout the country, and I, shared that article with lots of them. And it's interesting, depending on what side they're on, oftentimes what their opinion is, not just of that article, but of the way that plea bargains work. I know one jurisdiction in particular that has a very, very high conviction rate, like very high, very, very high 90s, like above 95% conviction rate. And the vast majority of that percentage is plea bargain. And so there's questions in the community about, are some of these folks in cahoots? Because that's a really, really high conviction rate in a place that has a lot of educated folks. So they're able to weigh the facts. They're able to do things that we don't really think that people maybe in other communities can. So I want to first ask the question, because I know you mentioned earlier, that's one option that your clients do opt for. But I'd like to know, from a general perspective, what are your thoughts on the way that the plea bargain process works, and give our listeners just some insight